Aging Aitken Robertson to courtroom number 2. The jury is back with a verdict. Members of the jury, how do you find the accused? Guilty or not guilty?
Not guilty on all accounts, Your Honor.
Welcome back to Legally Speaking, the YouTube channel brought to you by Aitken Robertson. I am Melanie van Orde, your host and paralegal at Aitken Robertson. Today we are tackling a crucial topic: what to do if the police call and request you to provide a statement at the police station. Joining me today for this discussion is our esteemed lawyer, Counsel Richard Aitken. And if you ever found yourself in this situation and wondered about your rights and options, stay tuned as we provide some valuable insights and guidance. Hi, Richard.
Morning, Mel.
How are you?
And doing well in yourself.
I'm doing fine, thank you, Rich. Richard, so let's say, for example, the police phoned a client and they are about to seize their electronic devices and they are requested to come in for a statement or to provide evidence. What should they do?
Sure. It used to be the police would simply show up and arrest, but since COVID, things have changed remarkably. Often you get a bit of warning relating to electronic devices being seized. Often you have an inkling in the back of your mind where you think that's about to happen. In a domestic situation or a fairly modest set of facts, the police may call and say, there's two ways this can play out. We can show up and arrest you, or you can go down to the station voluntarily. Now, you can't be compelled to go to the police station voluntarily, but often it's better to do in terms of doing things the way you want to on your own schedule, so you're not picked up from your house at 3 o'clock in the morning, and so that you can prepare. So in these kinds of circumstances, we meet with our client and we develop a very special letter which factors in the unique circumstances that the client has told us about their situation. And with the history we've had with other clients in police interviews, it's basically an instruction book of what kinds of questions the police will ask and how the client should respond to it. Police tend to follow a certain strategy depending on the nature of the case. And we want to make sure the clients are aware of the strategy, the goal of the strategy, how the police will try to execute the strategy, and the best way to respond. The best response is always, of course, to say no comment, no matter what the question is. But unless you understand the psychology of what the police are trying to use, you may still make a statement. In the past year or so, we've probably done 30 or so letters of a similar nature with quite good results. Before that, even if I would spend a half an hour or an hour with the client telling them why they should not make a statement, going over and over it again, often still would ultimately. But with this letter, the clients actually understand more about the psychology, and so far, no one's given a statement. The advantage, of course, is if the police do not have a statement, their case is much weaker.
And I think the fact that we also give them examples of the questions makes it a little bit easier for them to understand exactly when and where to say what to the police during the statement.
That's right. And the letter is pretty accurate, and then we tend to add to it. So after the client's been interviewed by the police, or the police have tried to do the interview at least, we ask the client about the questions. And sometimes there's new material. We add it to our letter to make sure it's very comprehensive and complete. Sometimes the police get very frustrated and it may slam doors and filing cabinets and so on. But at the end of the day, client does not make a statement. So many more will win in that situation than if they actually make a statement. I should go over why the making of a statement is important not to do. And the reason is, even if you are telling the truth when you're talking to the police, and you're telling the truth, the matter goes to trial, memories fade, as well as you'll answer the question differently depending on how the question is asked. who's asking the question, the intonation of the person's voice, the words they use in the question, and so on. And the Crown Attorney will say to the judge, look, judge, these statements do not match up. Can't keep the story straight. He's lying. There may be a time and a place for your statement. The time and the place is not now. And your lawyer can provide the evidence to the Crown Attorney without risking being cross-examined. Much safer environment. So do not, under any circumstances, make a statement to the police, whether a confession or otherwise. Sometimes seemingly harmless statements come back to bite the person. Don't do it. The only thing you should be saying is no comment, and simply keep to those words. Don't say, on the advice of counsel, I have no comment. You simply say no comment.
When would you advise clients or potential people that might face this to reach out to a lawyer if they are facing a similar situation?
As soon as possible. Normally, the police will say you have until the end of today or end of tomorrow to show up. So you have a window of opportunity. So find a lawyer who has the time and the interest in talking to you. Meet with the lawyer and get advice. If you decide you want to meet with us, we'll review the prospects of what a letter may provide you and how it might be important to your case.
And then after the clients receive the letter, are there any other steps that we at Aitken Robertson tend to take?
Sure. Now it's your chance to cross-examine at that point, and I do as well. And when we become pretend police officer, we put the client through a vigorous cross-examination to make sure the client understands how it all fits together and what the police are trying to do, and by way of example, what you and I are doing. And it helps the clients make sure they don't ultimately make a statement of any sort.
And then I'll probably also just add that we also include in the letter, should the client be held for bail, all the information that we will need to run the bail hearing, should it come to that, just as an additional add-on for the client.
Sure.
Well, thank you so much, Richard, for joining us today. And thank you to everyone else for joining us today on the Legally Speaking Aitken Robertson YouTube channel. So don't forget to like, subscribe, and hit that notification bell so you never miss another video. Until next time, stay informed, stay engaged, take care. Thank you for tuning in to Legally Speaking, proudly brought to you by Aitken Robertson Criminal Defence. We represent clients facing criminal charges all over Ontario, providing you with legal support and dedicated advocacy. If you enjoyed this episode and want to see more content, please like and subscribe to our channel. For more information, visit our website. We also offer free books on various types of criminal charges, which you can request on our website or by using the QR codes on your screen now. For legal assistance, call us today or visit our website to request a meeting with one of our experienced lawyers or licensed paralegals. Thank you for watching, and we'll see you next time on Legally Speaking.